Welcome back. So today we're jumping into a really fascinating legal case from the 1960s. It all boils down to one powerful idea. Can just a few words, a simple piece of advice, end up costing you a fortune? We're going to see how a seemingly casual comment led to financial disaster and completely rewrote the rules for professional responsibility.
And really, this is the core question, isn't it? Can you be held liable for some careless advice that costs someone a ton of money, even if you never signed a contract? As we're about to find out, the answer turned out to be a very complicated and honestly, a pretty mind-blowing yes.
All right, so picture this. We're in the bustling advertising scene of 1960s London. Our story has three main characters, if you will, an ad agency, their client, and a bank. And their little business deal, it's about to make its way to the highest court in the UK. Okay, so let's break down who's who. First up, you've got Hadley Byrne, the advertising agency. They're on the verge of signing some huge contracts for their client, Easy Power. But they wanted to be smart about it. They needed to know, was Easy Power good for the money? So they went to the source, Easy Power's bank, a company called Heller & Partners. So just as a totally normal business precaution, Hadley Byrne told their own bank to go and get a credit reference from Heller & Partners. This was a really critical step, right? They needed to make sure their client was financially solid before they put their own money on the line. So what did they get back from Heller & Partners? It wasn't some long, detailed financial report. Nope. It was just a short letter. A few lines of text that were about to become some of the most analyzed sentences in legal history.
And at first glance, the reference seemed pretty good. The bank said that Easy Power was, and I quote, considered good for its ordinary business engagements. For Hadley Byrne, that was basically the green light they were waiting for. It sounded like a solid thumbs up.
But, and this is a huge but, tucked away in that reference was a little disclaimer. It said the advice was given without responsibility on the part of this bank or its officials. Now, back then, that might have just looked like standard legal boilerplate, but let me tell you, those words changed everything. So, feeling confident after that reference, Hadley Byrne went ahead with the contracts. And then, disaster. Shortly after, Easy Power went bust. They just collapsed. And Hadley Byrne was left holding the bag for £17,000. That was an enormous amount of money back then. We're talking over £300,000 in today's money. Ouch.
So naturally, Hadley Byrne sued Heller & Partners. Their argument was simple. Your careless advice cost us a fortune. And this put the courts in a tough spot with a totally new question. With absolutely no contract between them, could the bank really be held responsible for just words?
Now, before this case, the law was pretty clear-cut. If your carelessness caused someone physical harm, sure, you could sue. But for just financial loss, what lawyers call pure economic loss, courts were really hesitant. They were worried about opening a Pandora's box of lawsuits. So the rule was simple: no contract, no liability. But the House of Lords saw that the world was changing. Professional advice was becoming a currency in itself. So they made a revolutionary decision. A duty of care can exist even without a contract, as long as there's a special relationship between the two parties. This was a total game changer.
And just like that, this case gave birth to a whole new legal concept: negligent misstatement. Basically, it means that if you give sloppy advice, knowing someone is going to rely on it, you can be on the hook for the financial fallout. Suddenly, your words carried some serious legal weight.
Okay, so what in the world is a special relationship? Well, the court actually laid out a pretty straightforward three-part test. First, the person giving the advice has to have some special skill, like a bank giving financial advice. Second, they have to know that you're relying on that advice for a specific reason. And third, you have to actually and reasonably rely on what they told you.
So the court creates this incredible new legal principle. And you're thinking, great news for Hadley Byrne, right? They're going to win for sure. Well, hold on, because there was one last twist in this story, and it's one that catches a lot of people by surprise.
That's right. After all that, after creating a brand new way to hold people liable, the court ruled against Hadley Byrne. They lost. They walked away with absolutely nothing. So what on earth happened?
It all came back to that little disclaimer. The court said that, yeah, a special relationship did exist, and yes, a duty of care could have been created, but Heller & Partners had killed that duty of care with that one sentence. They had basically said, here's the info, but you're on your own. We're not responsible for it.
So the final ruling looked like this. Yes, the idea of negligent misstatement is now the law of the land. And yes, there was a special relationship here. But, and this is the key, that tiny disclaimer worked like a legal shield. It allowed Heller to just opt out of being responsible.
So you could say that Hadley Byrne lost the battle, but their case absolutely won the war. The legal precedent that it set has had these huge, long-lasting effects that still impact all of us today.
At its core, Hadley Byrne v. Heller is the reason that professionals today can't just give out bad advice and get away with it. It cemented the idea that if you have expertise, you also have a responsibility, even if there's no fancy contract sitting on the table.
Just think about who this affects in our world. It's the bedrock of professional liability for financial advisors, accountants, consultants, you name it. But it also raises some really interesting modern questions. What about that social media influencer giving out stock tips? Do they have a special relationship with their millions of followers? The lines are definitely getting a bit blurry.
And that leaves us with one final thought to chew on. This case from the 60s about a bank and an ad agency is raising a very 21st century question. In a world where we're drowning in advice from influencers, from algorithms, from AI, who's responsible when that advice turns out to be wrong? The principles from Hadley Byrne are more relevant now than they have ever been.